Yes,
So,
Your Honor.
You'll have a total of 15 minutes to present your arguments. And the state has waived.
Let me know when you're ready.
Go ahead.
May it please the court, I'm Denise Ferguson, and I'm here on behalf of Mother Kelly Petrocchi. I would like to reserve 5 minutes for Attorney Hightower to present her argument. Part of what I'm going to say seems like a repeat of what I said to you earlier. It
Imagine that.
may just be easier to say ditto, but I don't, insert your own names. But we will continue. I am here on 2 arguments, assignments of error. The trial court committed reversible error when it terminated mother's and father's parental rights rather than granting legal custody, and the trial court committed reversible error by giving weight to a GAL who did not complete his duties as required by statute. And I'm going to start with the second assignment of error, if that is okay. The statute that I'm referring to is 281 It states the guardian ad litem for an alleged or adjudicated abused, neglected, or dependent child shall perform whatever functions are necessary to protect the best interest of the child, including but not limited to investigation, mediation, monitoring court proceedings, and monitoring the services provided the child by the Public Children's Services Agency or private child placing agency that is temporary or permanent custody of the child, and shall file any motions and other court papers that are in the best interest of the child.
Now this, as I recall from the briefs, this particular argument is advanced on plain error because no objection was raised below. Is that correct?
Well, I did not argue plain error, Your Honor, and I say that Father did, though. Father did argue plain error in his response brief to mine. And if you would like, she can join me at the podium and...
No, that, I mean,
okay.
that's, we've read the briefs, that's just, I'm just trying to keep all this
I
sorted
was-
out. And you don't get credit for what the other party did. I'm just trying to focus in on how we review the assignments of error that you have raised on behalf of your client.
My argument was based upon the fact that the trial court, in misapplied whether or not the guardian ad litem did his job per the statute. And when she gave weight in her entry that the guardian actually did his job and found what was in the children's best interest. My confusion, well, one of the reasons why I did not claim plain error was because I was appealing from what the judge found in her journal entry.
About the GAL.
About the
having
GAL.
made this very complete, thorough investigation.
Yes.
Okay.
So I did not plead plain error because it came straight from the judge's journal entry of what I was appealing from, her findings. Now, while the judge did say he did the guardian ad litem completed a thorough and comprehensive investigation. He is familiar with the home environment while the children were in the custody of the parents. He has also witnessed the difference in the boys' lives since coming into care. The guardian ad litem believes it is in the best interest of the children to be placed in the permanent custody of Summit County Children's Services. Again, as earlier, this was a CASA GAL, a different CASA GAL. This man's name was Lawrence Reinhold. He was also an attorney. However, he was functioning as a CASA and not as an attorney for the children. When he looked at the children's homes, where they were staying with foster parents, they were doing better in school, he stated. The children were in a better school district than Akron Public Schools. They moved from a school district that is in the city to one in the suburbs. Class sizes were smaller, there was a different dynamic. And this is nothing against Akron Public Schools. I live in Akron, my kids go to Akron. But his findings, or what he testified to, were instances that could not be helped by Akron Public Schools. They can't change the dynamic of a classroom or the makeup of a classroom. They could not change what the children could afford to wear in their classrooms. They could not change how many students had to be in classrooms. That's beyond their ability as a school district because they don't have the funds to hire more teachers like I believe it was the Green School District could, where the children were placed in foster care.
But it seemed to me, reading the court's entry, that the court went out of its way to indicate that the decision was not based on financial ability. That the court was almost, while these issues had arisen, that the court was not taking into consideration matters that were outside of the parents' control, but rather the fact that the parents didn't avail themselves of resources that could have helped the children's situation.
Well, I mentioned that because that was part of the GAL's thorough investigation, or what was referred to as a thorough investigation. I also would like to mention that, that was just one portion of it. Other things that this individual did is he criticized how Dr. TK, he stated, misdiagnosed the kids, they need a psychiatric evaluation. And then he never followed up to find out the outcome of the psychiatric evaluation. He didn't know if the doctor that did a new evaluation found anything differently. He didn't talk to AT's counselor, probation officer, or know the outcome of AT's delinquency hearings. And that's important because one of the reasons why these children could not go home is because AT not allegedly, because he was adjudicated delinquent for it, perpetrated a sexual act upon his brother while in foster care. In July of 2015, one of the boys was sexually assaulted by AT, his older brother. This child then was supposed to get into counseling, and the agency never put this child into counseling until after they filed for permanent custody.
You mean the child that was offended?
The child that perpetrated was never placed in counseling of any kind until after they filed for permanent custody. Even though that child was in the temporary custody of the agency. And even though the sexual offense happened under the agency's watch in an agency-approved foster home. Now, this child, the other problems with Mr. Reinhold's investigation was he got all of his information from the caseworker. That again is still a problem because the caseworker in CSB wanted these kids in permanent custody. They didn't want the children to return. If he's only listening to one side of the story, he's not doing a complete thorough investigation. You can't get more than one side of the story unless you talk to more than one person. He never talked to the counselors for the other children, including the counselor of the child who was perpetrated upon. He never talked to various other professionals that were involved, including a fast-track worker. He based everything upon what the agency told him, what the agency wanted. The other issues with the GAL is he referred to one of these children as a postal worker waiting to happen. He criticized another of the children as being nothing more than a dandy. He also, every time his attorney, the attorney for the CASA program, said anything, objected to it. He objected against his own attorney during the entire proceedings. This was a guardian that did not know what his role was supposed to be or how best to implement it. He did not do his job under the statute. His testimony should not have been given any weight for these issues. I do go into more detail on that, but I do want to talk about the first assignment as well.
You're at the 5-minute point now.
Well, then I will yield, and if she has time left over, then you're welcome.
Good morning, Your Honors. I will take 10 seconds just to say it's been an honor to practice in front of both Judge Miller and Judge Whitmore, and this may be my last oral argument before the two of you again.
Thank
So
you.
I wanted to let you know that. I'm not slighting you in any way.
I didn't feel like that.
Thank you.
She's gonna be around for a while.
Your Honors, the main, I think manifest way, there's so much that can be in manifest way, which is in support of the appellant's first assignment of error. I think the guardian ad litem is the issue I'd like to more readily focus upon. Although we do support both assignments of error, which we have outlined in our brief, which were presented by Mother as my client, Stephen Quattrochi, had filed for Mother to obtain custody of the children. I think the issue with the second assignment of error is they're really based on some of the case law regarding guardian ad litems that have come out in various cases since Rule of Superintendent 48 was passed. There's almost no mechanism for a trial court lawyer to actually challenge the use of the guardian ad litem's report. We have attempted to challenge it by objecting to the report, but then it's not a piece of evidence because it's a piece of the record, so you can't object to the report. And we understand that the court's, that the Supreme Court's mentality or attitude towards it is that, you know, there's the credibility of the witness, and the court has the ability to gauge the credibility of the guardian ad litem as they do with anybody else. But what we're left with is we've got a guardian ad litem who clearly didn't understand his role, objected to his attorney representing him, objected to any evidence placed on by his attorney, and admittedly, in a clear and convincing evidence standard case, admittedly said, hey, I'm on the fence, 41%, 59, 51%, 49%, meaning 51% in favor of the state, 49% in favor of the mother, as to him determining best interest, and in the state he's considering foster placement where these children were placed. So I guess as a policy issue, there's got to be some mechanism if a guardian ad litem completely blows their role for us to be able to come to the appellate court, because we don't know how much weight the judge has put into this guardian ad litem's testimony until we see the journal entry.
Well, let's go back to the statement about being on the fence and 49% to 51%. Does that present evidence that the standard of clear and convincing evidence has not been met?
I believe that it supports further evidence in the case that clear and convincing has not been met. So I don't think it's necessarily dispositive of whether clear and convincing has been met, but to use best interest as one of those components when there's a 1% difference between whether mom gets custody or whether the state gets custody, I think that shows that there's a reason to recognize that this mother should be getting custody, and that should also demonstrate that it's a harder burden for the state to meet clear and convincing evidence when a guardian feels that way about a case. Does that answer that?
I think so.
Well, it's hard to see whether it falls in favor of both parents.
Well,
It just simply because it's so close, it doesn't really have any weight then, is what you're saying.
I'm saying it doesn't, and I think he did testify that there's no definitive objective standard for best interest, and it's kind of hard to call. He even said so himself, it's kind of hard to call. And with that, I'm not sure that permanent custody, I mean, the death sentence to parents should be granted when the person responsible can't even really say definitively if those parents shouldn't have their children.
You know, as you kind of step back and look at this case, there's a lot involved. And some of this may go to the manifest weight issue, but it may also go to the GAL. You know,
responsibilities of the guardian ad litem to be able to research those things, to address best interests. I think one part of the answer is I can't talk specifically about the conditions of the home recently after the PC or around when the PC motion was filed, because I don't believe the person who would investigate on behalf of the court had actually looked into that circumstance. And as to the second part of your question, which was, I'm sorry, what was the second part?
Just the impact that those conditions had on the behavior of the children.
I think that, as mentioned previously by counsel, we're not sure quite of the impact because of the psychological assessment and the results and that not being able to be ascertained. But the trauma that I believe was discussed during the trial, I believe was the trauma related to the sexual abuse while they were foster children. And I think that that shouldn't be negatively attributed to the parents' progress, because I understand they were in state's custody due to the parents' involvement with the state, but certainly no parent would have wished that their child would be placed in that situation. So I think more of the psychological and behavioral issues